about that. Like, see,
अच्छा अच्छा, ओके।
right. So,
No,
like,
चलिए
that's
we
सर,
can
अब हम
come
ऐसा
that.
करते हैं, वी हैव ऑलरेडी एक्सीडेड 10 मिनट्स, एवरीबॉडी इज वेटिंग, लेट मी जनरली हम ममता जी स्टार्ट करते हैं, मोस्ट ऑफली शी इज नॉट एबल टू ज्वाइन, तो लेट मी फॉर्मली स्टार्ट माय प्रोग्राम एंड गुड इवनिंग रिस्पेक्टेड सीनियर्स, फेलो इंसॉल्वेंसी प्रोफेशनल्स, जग aspirants and distinguished speakers. It gives me immense pleasure to welcome you all to today's knowledge session, being 85th webinar seminar of IPA. Let me begin with a brief introduction of IPA. And my our brief introduction is IPA was founded in on 15th of November 2017, 8 years, 3 months ago, by me along with late Shri Navjeet Singh ji, with a vision to create a truly national platform for insolvency professionals across India. We began with 11 IPs from 7 states to give it a genuine all India character. What started as a small initiative is today a growing professional movement of with 320 members and steadily increasing. The core philosophy of IPA is very simple: to impart knowledge, build professional capacity, and uplift especially the young generation of insolvency professionals. We are not merely an association, we are knowledge sharing ecosystem. Our journey and contribution, IPA has always been in action not just as an association, but otherwise also. We facilitate, in generation of works, especially as value or forensic editors, advocates, whatever assignment we do get, we always share it among our members so that they can also join us. Recently, we got some, Mumbai assignment which we shared with one of our fellow members. He is also our governing body member also. Plus valuation, forensic audit assignment. Only in the last fortnight, 2 assignments have been shared. We conduct our webinars and physical meetings also. Physical meetings are generally at a periodicity of a year, one meeting in a year, or 2 meetings in a year. We have 2 YouTube channels also, one run by me and another by Anil ji. तो इन दोनों के एड्रेसेस मैं अभी चैट बॉक्स में डाल देता हूँ, तो प्लीज लुक इनटू दीज 2 YouTube चैनल्स, यू विल फाइंड देम क्वाइट फैसिनेटिंग. लेटेस्ट अभी हम लोगों ने जो करा था, वी इम्पार्ट आवर नॉलेज एंड शेयर नॉलेज इन व्हाट्सएप ग्रुप, अराउंड 50 ग्रुप्स which we exclusively run for IPs. Our first physical meeting was held as back, as on 10th of March 2018, when we then invited our honorable NCLT chairman, Mr. Mukhopadhyay ji, as an invitee. The latest meeting was held as on 25th August 2025, where we deliberated on the proposed IBC 2025 amendment bill, and it was conducted under the guidance of Ms. Anjana Gupta from IBI. After elevation of Shri Nilesh Sharma ji as judicial member, Shri Anil Goyal ji accepted the responsibility of Vice President as on 7th of November 2025, strengthening our institutional framework. I also acknowledge his valuable inputs provided in submission of the memorandum on IBC 2025 to Select Committee as on 4th of November 2025, and his contribution at the resolved 2025 International IBC event at Mumbai on 1st of 2nd December 2025, where I was one of the panelists. On personal note, I must confess I became insolvency professional after attending a lecture in January 2017 by Madan sir, but carried his legacy further by inspiring many others to join the noble profession. If even a few IPs say that they cleared the exam after hearing about IBC from me, that's my true professional reward. Now let me move to the technical topic for which we all has gathered together here. Very recently, as on 9th of February 2026, the Honorable NCLT Principal Bench New Delhi admitted a petition under Section 245 of the Companies Act 2013, filed by minority shareholders holding approximately 5% share capital. The decision was ratified what may be called as a sleeping giant, the class action suit mechanism. Section 245 read with Rule 84, and Rule 87 provides a statutory recognition to collective shareholders' action where affairs are conducted in a manner prejudicial to the company or members. Statutory threshold is satisfied. Tribunal forms a prima facie opinion, and in the recent order confirmed this satisfaction and issued a notice by NCLT Principal Bench. Importantly, the tribunal also reaffirmed that Section 245 is a statutory remedy distinct from derivative action under United States jurisprudence. What derivative action is, sir, हमारे को enlighten करेंगे आने वाले detail there. when we are preparing, analyzing Section 245 with IBC, I come out with a one very big difference that in IBC, claim is recognized when it is filed. But in this case, a member is recognized the moment public notice is issued against him until unless he opts out. With this note, at the same time, it may create a lot of opportunities for we professionals also, because we can start practicing on this particular Section 245, helping minority shareholders in furthering their cause. And other things which I could find out is that we just to know about this, let's understand deeply what Section 245 is, build coordination with our advocates and forcing editors, and all this is a broader aspect. With this background, now I hand over my session to our respected Vice President Shri Anil Golji, who will enlighten us further us with the expert inputs of Madan sir, PS and Prasad sir, in understanding that what is the class action suit under Section 245, what are the procedural aspects in it, what international scene is there, and how tribunal approach, especially overpassing USA's settled principle of derivative benefits, with reference to their interpretation of Section 245 of Companies Act, and at the last, how we professionals can get benefit of it, and build our practice specifically with this class action suit. Sir, Anil sir,
Thank
now I
you.
hand
Thank
over
you.
the baton to you. Please come forward and enlighten us with your sharing of this thing. Let's continue to learn, grow, and strengthen the insolvency ecosystem. Please, sir. Welcome, sir.
ममता जी का स्वागत
Thank you
भी
very
करूंगा।
much, Vinod ji, and
नमस्ते।
जी नमस्कार.
जी ममता जी नमस्ते।
हाँ
आज
नमस्ते।
आपका
Today's
इंट्रोडक्शन वाला काम मैंने करा।
थैंक यू सो
no,
मच।
I think
चलिए
Manoj ji has done your part, but still, like there is a lot of other things that your experience actually will be very, very useful for all of us. So today's discussion, we would be the entire panel. I would be introducing for this discussion on Section 245, the class action suits. First of all, Advocate G.P. Madan, he's a noted lawyer, and he's also chairman of the insolvency and other, I think, the committee of the PhD chambers. See, Dr. PSN Prasad will share his experience as he might have experienced while he was a member of NCLT. And as far as Mamta ji is concerned, she is the former national president of Institute of Company Secretaries of India, and who knows Companies Act more than her. So this is something which is the Companies Act issue. And even if our association, even if most of us are insolvency professionals and lawyers, but yes, this is a Companies Act issue. So the Prasad Sab will speak about the difference between the compromise and arrangement scheme under Section 241 and 242, and
compromise arrangement under 230 to 232.
232 and 230. Yes.
Operation
regularly I'm doing 230, so I'm actually compromise arrangement. So and then we will let us now start this discussion on class action suits and Section 245. No, what I want to say,
sir, एक मिनट में आपको रोकता हूँ. Mamta ji, would you like to have 1 or 2 minutes to you just join later on to start with, please?
Thank you so much for the opportunity. I actually, as Anilji also said, but first of all, my greetings to everyone. Prasadji, thank you so much for joining, and so did Madanji and Anilji, and of course our President Manojji and all others. Very quickly, I want to say that, see, 245, Section 245 has been latently lying in our law books for long. Okay, it was notified in almost 2016 June, is what I understand. And it has just come into play in 2026. Definitely it took 10 years for class action suit to really come in the forefront. In fact, I have had the experience of also running a case for one of my clients where it was rejected at the admission stage because you really need a lot of also wherewithal and guts to admit such a petition. It is open to so many challenges, and what I also would like to say that when you look at it, it is also open to quite a number of misuse. Of course, anything for that matter, which comes into the hands of anyone for that matter, is open to advantage and also disadvantage. Something which is an advantage to one is a disadvantageous to others. So if that be the case, the stake in 245 is very, very high. It's extremely high, and it is very, very highly open because it says it is prejudicial to the affairs of the company, etc. So a lot of things comes into the playground of 245. One has to be extremely conscious and cautious when invoking 245. And what I also fear, and very quickly then I hand over the baton, what I also fear is the media trial that starts happening. Because in section 245, normally we will see that listed companies will come into listed companies will be there on the other side as respondent, because all of it will be obviously against the company, and maximum times we will see listed companies coming into the forefront as a respondent. And when that happens, I'm afraid that the trial, apart from the NCLT trial, will parallelly open, and that is quite a pain point for a listed company, because at each news, the share prices will fluctuate like anything. So it is also very detrimental to the public at large, because 25% is held by the public. So we have to be, as lawyers or as professionals also, one has to be extremely responsible, taking a responsibility while running this case. And now that I give it to Sir, I just want to say that this is very, very wide, because as experts, we all are professionals. So case आज हमारे अगेंस्ट पे भी लग सकता है. आपने कोई ओपिनियन दिया और वो ओपिनियन के बेस पे कुछ हो गया, तो इवन नाउ वी कैन बी अ रिस्पोंडेंट. बट इन दिस 245 वी आल्सो फियर दैट professionals sometimes are just the easy and the soft targets. So, we may be targeted as the compulsory respondent. ये जो मैटर अभी आप पॉली फिल्म्स का देख रहे हैं, जिंदल पॉली फिल्म्स, इसमें भी कंपनी सेक्रेटरी जी को लिखा गया था, सीएफए को लिखा गया था कि ये इन्फॉर्मेशन दे दीजिए. उन्होंने कहा कि हम नहीं दे सकते, ये पब्लिक इन्फॉर्मेशन नहीं है, एंड ऑल दैट. सो जब ये सब एक्सचेंजेस होंगे तो वो भी पार्टी बनेंगे. सो दिस इज लाइक a very wide opportunity वगैरह तो सब चीज में ही होता है, but this is an opportunity with lot of responsibility.
Yes, thank you. Thank you very much, Mamta ji.
अनिल जी, ममता जी के लास्ट सेंटेंस के ऊपर मैं वुड लाइक टू कंटिन्यू. ममता जी ने कहा कि कंपनी सेक्रेटरी के ऊपर भी होता है. इस केस में द कंपनी सेक्रेटरी ऑफ द कंपनी रिजाइंड ऑन 9th of November with effect from 9th of November. I mean, a KMP resigned from the company with immediate effect without handing over the charge. It means there must be certain other reasons also, because if nowadays an independent director as well as a KMP is, whenever giving the tendering the resignation, has to write in the resignation letter the detailed reasons of resignation. And the reason of resignation which has been mentioned in the resignation letter, which is available on BSE website, is that personal reasons. Because of personal reason, the date is not always the same. Certainly, it has to be a prospective date. You always take a time, 1 month, 2 months, and hand over the charge. However, recently on 7th of February, some other company secretary has been appointed in the company.
No, I think thank you for this update.
Yes,
But
yes.
see, I think let us start now the way we had planned this webinar. So in case we need to introduce a little bit of section 245. So I would not say much on this, because if there are allocations of different parts of this webinar to all the panelists. So like I can only say one thing, that see, the government of India in fact felt the need of it during Satyam scandal in 2009, when they felt that in India there is no provision for class actions suit. Now, in USA, for the similar case, in fact, the the US class action suit, in fact, there was a settlement of approximately $125 million, whereas in India, there was no provision. In fact, after this, even J.J. Irani, in fact, before that, J.J. Irani committee also recommended that there has to be class action suit for minority protection. So therefore, in this particular section 245, this was not notified in 2013. It was notified on 1st of June 2016. However, the relevant amendment in the NCLT rules, in fact, it was done with effect from 8th May 2019 through NCLT Second Amendment rules. Now, this reason for this Satyam scandal, I think that was the kind of alert that the government, in fact, started. And when this rule was, in fact, made, and let us go to the little bit of background. For all these years, the first stage of any class action suit is the admittance. Now, whenever the case is admitted, like for example, Jindal polyfilm case, it was admitted. I will ask Mamtaji to give us the brief about this case. However, I would like to clarify one issue, that immediately after the admittance, there was a direction to issue public notice regarding class action suits. In the public notice is that anyone who want to opt out from this class action suit, it is only for them. So in case, I believe the promoters will opt out, any associates will opt out. So anyone not opting out within the stipulated period will become a class. So that class is actually a minority class, because that would be considered as the beneficiaries in case of any settlement or any compensation is awarded later on. However, when we say that the case is admitted, it is based on the primary evidences. Now, after that, once the class is determined, once the class is made, and thereafter it will be heard and it will be decided what kind of loss has actually been caused to the minority shareholders and what kind of compensations would be payable either from the company or from the persons who are responsible for this. So before we go ahead and before we talk about the provisions of Section 245, I would ask Mamtaji to give briefly what this case is all about and how it is finally kind of now it is important for all of us to discuss the further further impact on this entire ecosystem. Yes, Mamtaji.
Sure. Kindly give me the screen share rights, if possible. Chandanji, in the meantime, when you give me that, I just give you a brief synopsis. See, of course, in this application, there are the petitioners and there are the respondents. Now, what happened in this was there, if I can show you in short, it will be nice. Just give me a minute, because this will really help. अगर हमको screen share आप दे देते.
Chandan, can you provide that? Manoj, you are mute. Manoj, you are mute.
जी को प्रोवाइड कर दिया, बाकी सबको मैं प्रोवाइड कर रहा हूँ.
अच्छा, okay. So just give me a minute, please. I have written an article on this where I'll just show you in brief I have written, and I think showing will be better. Just 1 minute. I just finished the article today. Yeah. Must tell you that it is definitely a very big tool in the hands of so many people, but one has to be extremely careful while the court has to be extremely careful, I feel, because a lot of it will lie with the courts.
So while you are trying to
I have
this,
opened it, sir. I've opened it. Just give me a minute only. I think, yeah, just 1 minute. It will help, sir. Actually, I don't think it's opening. So let me just tell you. कई बार हम बहुत सारे बैलेंस शीट में देखते हैं that there are these related party transactions. Okay, sometimes we also see that these related party transactions have not been done with proper process of law, or we see that it is one kind of stripping the balance sheet of its valuable assets. Now, assets could be cash, assets could be all the other format of assets that is available in the balance sheet. Now, when that happens, it is easily, when you see the balance sheet with minute eyes, you will be able to see that, something or the other, you'll always be able to find out. Of course, there has to be a very grave thing, I'm sure, which will actually then be triggered to invoke Section 245. So in this Jindal polyfilm case, there was some loan. There was previously some loan which was then written off, okay, by Jindal Polyfilms. And when it was written off, some OCPS was issued. Then those OCPS were converted at a very less price into equity shares. And then those shares was actually sold to a related party at a very sub price. So, for example, if the valuation was about, say, for example, the valuation was 100 rupees, but it was sold at 2 rupees. So, therefore, the shareholder, which was Mr. Jain and the family, when they invoked Ankit Jain and others, when they invoked 245, they also said that all this has happened, which has stripped away the Jindal Polyfilms out of its valuable assets. Okay. Now, if that happened, so there are a lot of in this judgment, there has been a lot of words that has been used, like derivative action. It has been used that if a company is suffering a loss, of course the shareholders' share price will always have the impact of that loss, because the share price of that investor will definitely go down. So then, will that be a matter to be taken to the courts? Because that will latently happen, that if a company has endured a loss, the price goes down. So even can those issues can also be brought to the court wide the route of Section 245. So such issues has been delved deep into it. And in the Jindal Polyfilms case, why did it take so long? I mean, this was filed in 2024. So it took years, it took 2 years to actually generate an admission notice. So now notice has been issued. Now, this whole fight was being taken on two grounds: that whether this can be admitted, which means is it crossing the threshold. So in Section 245, for a listed company, the threshold is 2% of the capital, listed issued capital. Whereas in 241, 242, we know it is 10%. So in short, if I have to say that obviously the respondents went on to say that this is just a circumvening done by the petitioners, that they are not able to match the threshold in 241, 242, because the petitioners together represented 4.99% of the paid up capital, which is not 10%, but above 2%. So the respondents said that they are trying to circumvene the 10% because they are not able to match. So they have come to 245. So that was one very major issue. The maintainability issue was taken up. And they also said that these are all derivative actions, etc. These are all actions where loss has occurred and etc. How can these be a part of 245? So both these issues were furiously and extensively fought. And then the court said that, yes, I feel that there is something which the courts need to see, and the basic thresholds have been met. And we also don't see it as a derivative action. So therefore, they said that it needs examination by the judiciary, and hence it was admitted. So 2, 3 points that I would wish to just say, and then I wish I'll get my turn back again. But here I just wish to say that 245 and 241 will look very similar, but they serve very different purposes. 241, 242 is like आपके shareholding में problem है, directors have been ousted, majority has taken the control over minority, etc. But here 245 is like they see that the affairs of the company has been prejudicially run, and that it is hampering the shareholders at large. it cannot be done that if I am suffering, it cannot be done for me. It has to be a group of shareholders who's suffering through the same cause of action. Okay? So therefore, 245 is more of a action which is concerted. Okay. And what Anilji also mentioned is very, very interesting here, that if you're not opting out, then you remain opted in. So this beautiful concept of opt out, etc., has been borrowed from the English law. A lot of concepts have been borrowed, but definitely it will be tested in times to come. But all of it looks to be quite on a strong foothold.
Thank you,
Yes.
Mamtaji. So I would only add a couple of things, Mamtaji, not about that case, but we would say that let us understand what exactly this section 245 is, who can apply. So the first of all, section 245 subsection 1 deals with who can apply. So the first who can apply is the members or shareholders of the company. They can apply individually. They can actually also a group holding shares as per the eligibility criteria. They can also apply, including subscribers to the memorandum or the persons who agree to in writing to become members. This is the one segment who can apply for class action suit. The second segment is the depositors under the Companies Act, where the deposit has been accepted under the Acceptance of Deposit by Companies Act. Now, the third is the representatives. This is very important. Any person, group, or association acting on behalf of affected members or depositors, provided they meet the threshold and demonstrate common interest and grievances. So these are like, only my concern is this also may become almost a tradition in future that there will be associations which actually will get formed, associations of shareholders, and those associations will become very active. In USA, there is a law that all these class action suits are being fought by the uh, funders, by the litigation funders. These suits are being fought by the funders on sharing basis. Now, the grounds on which this actually application can be made, the very simple thing that we have to put before the bench is where the management or conduct of the company affairs is prejudicial to the company. So that means any transactions which are prejudicial to the company or its members or its depositors. So very simple, if it is prejudicial, then the application can be made. Now, this is, I just wanted to add a little bit about it. I think now I can ask Manoj ji, because he has studied in detail what are the eligibility criteria. Like how much is the eligibility for the members, how much is the for the associations, and what is the eligibility for the depositors. So very clearly, so that the audience will come to know what is the minimum eligibility required for submission or filing of an application under for class suit action. Yes, Manoj.
Yeah, Section 245, subsection 3 prescribes the eligibility threshold criteria. It is along with Rule 3 of the company's class action rules 2016. It has been, divided into three parts, and then further subdivided. Members, first of all, company having a share capital. In this case, 100 members or 10% of the total member, whichever is less. Meaning thereby, let's have we have 500 members. In that case, 10%, 50 member भी अगर होंगे तो आप क्लास एक्शन सूट फाइल कर सकते हो. यही अगर 5000 मेंबर हो जाते हैं तो 100 मेंबर ये क्या कहते हैं सूट फाइल कर सकते हैं. Only condition is that all calls and dues on shares must be fully paid. Now let's come to the second category. Company having this is, I told you, for the company having share capital. Company not having share capital. In that case, 20% of the total members. Only condition is that membership must be valid as on the date of the filing. Depositor, we talked about the depositor. Whether it is a listed or unlisted company, for all the companies, its threshold is 100 depositor or 10% of the total depositor, whichever is less. Nothing more to explain. this is the numerical threshold. As far as financial threshold is concerned, that will be depositors to whom company owes more than or equivalent to 10% of the total deposits, even if number is less. This is a very small condition that deposits must be subsiding. In the case of joint application, say one person is a shareholder also and depositor also. In that case, application may be filed jointly by the eligible class. Limits has to be seen, separately as a depositor or as a member. और jurisdiction जो है it will be the jurisdiction जो NCLT की jurisdiction है उसके accordingly उस NCLT के अंदर उसको ये फाइल करना पड़ेगा. This is all from my side, sir. Please carry on.
I think you are absolutely right. The only slightly that I would add, like there are for listed companies and unlisted companies, there is only one change. That for listed companies, the class, the applicant or group of applicants should have at least 2%.
Yes,
so
sir.
therefore, in this particular case, in the case of Jindal Polyfilms, it was 4.99 because the company is a listed company, so it was more than 2%. Had it been an unlisted company, then it would not have reached the eligibility criteria, because for unlisted company, the holding of the applicants should at least be 5% of the total issued capital. So one, and like in the case of depositors, I believe the percentage is 5% for the numbers as well as for the total deposits accepted. So I think the eligibility is actually very clear. And now I think now I would ask Advocate GP Madan to tell us about the something which is how you feel this is a professional opportunity, and what is the international scene on this class action suits, because I believe, because I was reading, it is more than 1 lakh international class suit actions has actually been filed in USA. So I think Mr. Madan can take over on these two issues.
Thank you, Gulsab. On the opportunity side, so let me share with you that on 13th of February, while NCLT Bar Association felicitated the outgoing president, Mr. Ramalingam Sudhakar, and had a farewell event. So I also had an opportunity to speak there, and I especially thanked Honorable the then President for opening an opportunity for the professionals during last 1 week before his retirement, when he came out with this judgment in Jindal Polyfilms case. I told him that this has become talk of the town, and actually this has activated the stakeholders, particularly shareholders and deposit holders, because in all other legislation, some of the other legislation we have seen, there is some sort of activism, maybe in Consumer Protection Act, maybe under SEBI laws, maybe under even this IBC also. I say this is nothing but class action when we talk about real estate allottees, when we talk about financial creditors in class. So there's a class action suit only when 100 or 10% of the home buyer they prefer an application. So that's also class action suit. But under Companies Act, though we had specific provisions of class action, but as Mamta ji said, it took 10 years to start with this. Now, Mamta ji touched upon also a very pertinent subject, pertinent issue, that is with respect to, and that's also an opportunity as well as a deterrence also. That under the 245, against whom an action can be taken. This action can be taken against directors, company, against the directors, against the officers, against the auditors, against experts, against advisors, against consultants, or against any other person against whom the allegation can be established. So from all these, the compensation may be demanded. Now, who are these experts? Coming to this term expert has been defined under the Companies Act 2013. And for this purpose, expert means a chartered accountant, a cost accountant, a company secretary, a valuer, an engineer, or any other professional who has been authorized by under any other law to issue a certificate. Now, if this certificate is issued by any of these professionals and the certificate is relied upon, and tomorrow if it is found that certificate actually concealed something, misled the public or misled this at least the company to whom the certificate has been issued, and the certificate has been acted upon, and because of the acting upon this certificate some loss has been caused to some of the stakeholders, this expert can be taken to task. And actually if we read the definition of the term fraud under section 447 of Companies Act, it is only malevolent intent which is material, ultimate result is absolutely immaterial. So even though a wrong certificate has been issued, whether some loss has been caused or not, somebody has gained out of the certificate or not is absolutely immaterial. The moment a certificate has been issued with some malevolent intent, this becomes a fraud. And for this fraud, the imprisonment, minimum imprisonment under the law is 6 months. So all these experts against whom this compensation can be demanded are also expert under the provisions of Companies Act. And then it goes beyond. It goes to consultant and advisors also. So I'm really worried whether the lawyers, advocates can also can be covered under this. Can they be called consultants or advisors? If they issue some legal opinion, whether legal opinion be covered under section 245 or not. This the water is yet to be tested. So as far as this is concerned, no doubt it's a great opportunity for the professionals that now they will be very, very accurate in providing the services. They will be doing their perfect due diligence before they issue any certificate. And the moment this particular action becomes a deterrence, I tell you the governance level in the corporate sector is going to be very, very high. And this governance is going to give a big opportunity to the professionals. The moment we have governance in the Indian corporate sector, this will act as a big boost to the professionals. One of you touched upon this public notice also. I don't know, sir, who touched. I think Mamta ji touched or Anil ji, you touched upon. After this case was decided, no, not case was decided, not case is not decided, only notice is issued on 5th of February 2026. An appeal has already been preferred before Honorable NCLT. And this matter was heard on 9th February, 10th February, 11th February, 12th February, and 13th February. For 5 consecutive days, this matter was heard. On 13th February, NCLT has asked both the parties to submit their written submissions. And now the matter is next listed on 20th of February. परसों matter फिर से लगा हुआ है. And in the 12th February order, the parties, the appellant said that the notice be not published on the website. We were talking about notice. Court ने उसको पर सिर्फ इतना remark किया that there is no timeline in the order to publish the notice on the website. The court has not said whether to publish the notice or not, but for all practical purposes, the order is not to publish the notice till that date. So notice is yet to be published, so even that option of opting out and opting in is yet to be exercised by the other stakeholders. Mamta ji also touched upon that this particular transaction was actually a related party transaction. Not one transaction, but all the transactions were related party transaction, issuance of CCPS, issuance of RPS, and then conversion and issuance of shares, and then the sale of shares. And there was one more transaction that the company Jindal Polyfilm granted a loan to one of these associate companies under some the power purchase agreement. That power purchase agreement got cancelled. And later on, the interest, the principal amount of loan, along with the interest of the loan, that were written off. So this again becomes a related party transaction. On this related party transaction, last year, the professionals who are dealing in the corporate, they know it very well, that SEBI came out with a standard, industry standard on minimum information to be provided to the audit committee before it approves a related party transaction. But what is that minimum information which should be considered by an audit committee before it approves a related party transaction? And in the audit committee, friends, it has been there in the LODR by SEBI that only the independent directors who are members of the audit committee shall approve a related party transaction. I'm really worried whether in this case, what those independent directors were doing when these related party transactions were happening. On what basis these related party transactions were approved. I tell you, this particular action of NCLT of issuing a notice only will act as a deterrence to independent directors also. While sitting at the audit committee before approving a related party transaction, they have to think twice, 4 times, 10 times whether to approve the related party transaction or not, whether they have the relevant information available with them or not, or whether this particular related party transaction is going to be the interest of the company and its stakeholders or not. So this is another great opportunity for the professionals. If you are willing to become independent directors or true independent directors, it's a golden opportunity that certainly now companies will be looking for true professional independent directors. Now coming to Anilji, you asked me about this difference between the US law and Indian law. You know, in India, Mamta ji said very rightly that 2013 से है, 2016 में नोटिफाई हुआ और 2026 में जाके इम्प्लीमेंट हो रहा है, 13 साल लगे. But in US, this legislation has been into the rule book as well as in practice for decades together. Hundreds of cases have been there and billions of rupees have been asked for as compensation and has been demanded also. Statutory framework there is very, very robust. While India, it's not so. India is talking about minimum threshold limits to initiate an action, while in US, it's not like that. In India, if a single shareholder wants to file a suit, go under 241, 242 if you meet the threshold of 241, 242. But if you want to come under 245, single shareholder cannot be there. It has to be class of shareholders, class of depositors. Here, the quasi-judicial authority is only NCLT. And Prasad Saab is here. I think, in my opinion, there should be some special colloquium for NCLT members as well as the company law is concerned, particularly with respect to now class action, the operation mismanagement, the class action suit. Because for last 6 years or 6-7 years, we have seen since the time this IBC has come, IBC came in December 2016. But particularly during last 6-7 years, the company has taken a back seat. Because of which many of the stakeholders who actually really want to initiate action under 241, 242 or under 245, they are not coming forward because they are of the view that NCLT is not listening our cases. Because NCLT is busy with IBC matters. For this purpose, again, to Parliamentary Select Committee, a suggestion has already been given and this there in the report also that NCLT infrastructure is to be increased. We need more and more number of benches. We need more and more number of members with some better infrastructure. While in the US, it's not there. US, there are established courts. There are time-bound judicial precedent. There are time-bound judicial pronouncements. Another difference between Indian law and US law. US law, the lawyers are filing these cases without charging any fee because there they can file the case on success fee based and success fee is exorbitant. In India, it's not possible because our Bar Council rules do not permit to charge fees on success fee based. In US, litigation funding is available. If a particular class is of the view that we need to take some action against the company, but we don't have funds, so the litigation funding is available. And the litigation financer, they get the money once the case is there, they are in their favor. Otherwise, it's okay, they lose their money, no problem. But in India, that litigation funding provisions are also not available. I think these are some of the differences between India and US, that India, the law on this is established, while here it is simply at a nascent stage where only a notice has been issued as on date. But I think some of us are forgetting there is one more case, the Thamapalli Rubber Company Limited. In that case, only on 12th of February, ये इसका ऑर्डर आया 5 फरवरी को, 12 फरवरी को वो केस 2018 से चल रहा है। 12 फरवरी को दोनों लॉयर्स ने आके बोला कि हमें इसका जजमेंट पढ़ने का टाइम चाहिए जी, उसके बाद हम देखेंगे इसमें क्या करना है। एंड ऑनरेबल चेयरपर्सन कोर्ट, जो उसमें भी प्रिंसिपल बेंच थी एनसीएलटी की, प्रिंसिपल बेंच हैज गिवन देम अ टाइम, ओके यू गो थ्रू द केस एंड देन कम फॉरवर्ड, एंड द नेक्स्ट डेट इज 19th of March. So after 19th March, we will not be left with one case only, we'll be there having 2 cases. और I tell you 2 cases बहुत हैं इस मूवमेंट को आगे बढ़ाने के लिए। And why I'm saying a movement, it is actually a movement. Let's not consider these are 2 solo cases. No, these are not 2 cases. This is a movement which has just started. It will reach heights. It will go further. सेबी में भी हमने देखा, सेबी ने भी पहले क्लास एक्शन सूट्स काफी किए हैं, उसमें काफी हुआ है इन्वेस्टर्स के बिहाफ पे। सेबी हैज पास मैनी ऑर्डर्स where many promoters of the company have been barred from entering the capital market. The many promoters, उनके डीमैट अकाउंट फ्रीज कर दिए गए हैं because they duped many investors of their money through the IPO route. This is the first round my comments, and I'll wait for the second round. Goel sir.
Thank you very much, Madanji. So I think he has touched various issues, and I would simply add, as far as these professional opportunities are concerned, one, that once these precedences are set, even the individuals, a group, they can also file an application under Section 245. The only thing is that they have to reach out to the eligibility level. And very simple. Now let us understand, because of all these startups where they are offering the equity shares to their ESOPs to their senior employees, and all those senior employees are also kind of understanding the what is happening in the company, and they keep collecting some evidences, and in case of any dispute, he can also reach out to a court with all those evidences. Only thing that he has to prove is that the management or the conduct of the company is prejudicial to the company or its member or its depositors. Now, it is simple to get evidences collected. It is simple to present it before NCLT. It is simple to get an order initiating Section 245 action. Now, it actually will become a later part of the total episode, that what kind of relief actually is finally ordered by the court and how that is distributed. I will only reach out to what kind of reliefs can be asked from the court and what kind of reliefs can be given by the court. One, that the tribunal in fact may give a preventive. Tribunal can give a preventive, means some kind of stay on some kind of transactions, or some kind of declaratory or compensatory orders which actually can be passed. So that means the stay can be granted on some of the activities or the transactions, and some of the actions can be declared as invalid. Some kind of compensations can be decided and it can be given, which actually will be distributed to the entire class. And also the tribunal can pass the order where it can actually restrain any kind of ultra vires of the company's memorandum or article, because in case anything which is prejudicial to the company, and any kind of resolution, any kind of actions which ultra vires the memorandum or articles of the association, or any action which are breaching the provisions of articles or memorandum, or even allow any kind of, like they can restrain any kind of alteration to memorandum and article, and they can also kind of restrain from the directors of the company, management of the company, from acting on some invalid resolutions which are passed. So the first most important is like declaring some actions as invalid, giving stay, compensation, and damages. And the other is restraining various things, like restraining various kind of activities. Now, it looks simple, as I said. Once the class action starts, it actually would be simple to go ahead and reach to a second level. It all depends upon the evidences and the nature of the transactions, that what kind of order is finally given by the court. Now I will reach out to Dr. P.S.N. Prasad. As I said, respectable former members of NCLT. I would simply ask Mr. Prasad, like, you have seen various applications under Section 241, 242, the operations and mismanagement. So what is those applications, and how do you differentiate between this class action suits?
See, the 241, 242 basically takes care of an individual rights agitator. But whereas 245 speaks about a class action, that is the basic difference. And secondly, even to exercise the power under 245, the powers conferred under 242 and 241 has to be looked into. Ignoring the existence of 241 and 242, you can't exercise 245. That is the magic here. Whether Madan agrees with me or not, 245 cannot be given an isolated reading. Though apparently it appears it can be given an isolated reading, it has a vital force drawn from the other provisions of oppression and mismanagement. The provisions of oppression and mismanagement have to be taken into account while determining the legality of action under the 245. Though guided by the broad votes given under Section 245, there is a harmonious relation between the provisions of oppression and mismanagement of an organization as well as class action. You can't really make them as independent, they are interdependent. Unless there is an oppression and mismanagement, the voice, nobody will raise their voice. That voice will be converted into a class action when few stakeholders comes together. Therefore, if a given chance is there, whenever 241, 242 application is filed, you should not only consider the scope for 241 and 242, you should also consider the scope for 245. Since 2016, the 245 section has not come into force, nothing could be done, and thereafter now it is a very wisdom step. I say it is a wisdom step where, see, minority, sticking to the numerical figures is one, and striking the concept of delivering justice is another aspect. That aspect has to be drawn from the spirit of 245 when you also handle the applications of 241, 242 in reference to 244. This is my primary view. And in fact, when I was judicial member where we were dealing with the matters of Unitech depositors, in fact, I have not 100% applied the spirit of 245, but 245 guidance has been taken into, while not only directing them to have their deposits returns, but also something more than interest and compensation. So in fact, this 245 today it was invoked, so we should not see it as something new, but no doubt it is opened another window. As Madan Saab has said, it is opened a new window for the professionals to game it from various angles and to exhibit their true professionalism. And every stakeholder has to be more vigilant, diligent, and do proper due diligence whenever they interact with organizations or would like to take a key role or would like to give some key opinion or would like to suggest them for some sale, whatever may be the nature of the transaction which affects the business interest of the organization, they should primarily say how the organization interest is going to be safeguarded by this action. For the time being, this is my view. Next round, I
Thank you
will
very much.
speak
Yes,
more.
thank you, Prasadji. Thank you very much. I would only add what Prasadji is saying. That is, in fact, very correct. Why I'm saying so? Because I was reading section 245, subsection 4. In that particular section, this is provided that what is the tribunal's scrutiny issues. What exactly the tribunal will see when such application is filed at admission stage. So the tribunal, in fact, what exactly the tribunal will say, first of all, the tribunal will see, as per Rule 85 of NCLT rules, the adequacy of the representatives, like the minimum criteria has been met or not. Secondly, the tribunal has to find out whether the evidences, whatever is presented before the tribunal, that the management's conduct is prejudicial to the company, members or depositors. For example, Ultra Wires Act, fraud, misleading, or statement by the auditors and advisors. So internationally, if there is any statement by the advisors or the auditors, those are in fact very, very relevant for starting class action suits. The second important thing which actually Prasad Sab in fact wanted to touch, that is the bench will ask why you could not go individually, why it should be a class action suit. Now, in this case also, in the case of Jindal Polyfilms, the Ankit Jain and family, they in fact pleaded that we together are only having 4.99% shareholding, and for the purpose of O&M, for the purpose of section 241 and 242, we need 10%. Therefore, we are unable to take at separate actions because we have insufficient, that is impracticable. So the other thing which is required to be produced before the tribunal is that the cause cannot be pursued individually and no prior similar resolutions or ratifications by the company. So that actually it is all related to the act of the company. Now, once the procedure for admission is done, then section 245 subsection 5 says that the public notice will be given, as I have already said. Also, in case such applications are filed at various stages, so it will be consolidated at one stage, similar application, only from same class of. Then there will be a lead applicant, which will be done by the, after the public notice, the tribunal will decide who would be the lead applicant. Then there is a bar on multiple class actions for the same cause. And also there is something like cost and who will bear the cost and who will not bear the cost. That's a separate issue. In section 245 subsection 6, what is written is that the order of the tribunal, it would be binding on the company, its members, depositors, directors, auditors, and experts or advisors or any associated person. That is what is in fact mentioned in section 245 subsection 6. Now, when we say all this, now we can again reach out to I think Manojji, when we have said all about like who can apply, what are the eligibility criteria, what are the powers of tribunal, what exactly has to be proved before the tribunal, and why section 241 and 245 was not practicable, and after this, what do you want to add? Why you think that this is not becoming a kind of, it will become virus. It will actually become viral. And also, don't you think that it will impact the conduct of the management of the companies? It will also help the minority shareholders, because the class is automatic. Once the public notice is given, automatic class will get determined, because anyone who will not opt out become a class. So therefore, one shareholder who has 2% shareholding in a listed company can go and file an application, and automatically the class will be formed. What you would like to add here as the opportunities for lawyers, or opportunities for even advisors like us to the companies?
सर इससे पहले मैं एक थोड़ा सा और ऐड कर दूं जो कि बड़ी मटेरियल बात है. वी इन दिस पर्टिकुलर क्लास यू हैव एन ऑप्ट आउट मैकेनिज्म आल्सो. Opt-out mechanism, let's understand, is like that. For example, if any of the class is formed, say some depositors are formed, and in those depositors, some management persons are also enrolled therein, or their related persons are also enrolled therein, and they don't want to, get benefit of this thing or continue of this thing. So then they can opt it also. So that is also provided under this thing there. Now let's come to, I was seeing one question in the chat box also. Will NEFRA will act on it or this is like that? In my opinion, it will definitely add a new dimension to our existing company management system. As far as 245 is concerned, it talks about the class. As far as 241, 242 is concerned, it talks about the operation and mismanagement. Operation and mismanagement cases, although Madan sir ne jaisa kaha ki were not being practically implemented and people were not doing it. But as far as 245 is concerned, it will definitely more make auditors, make experts more vigilant, make independent directors more vigilant, and minority shareholders will wake up. They will understand that we have a right for that. And here I would like to add one more thing. In India, we have exceeded even the US law also. We are talking about the derivative action. What exactly derivative action is? Derivative action mean that if because of any action of the company or of the or directors of the company, if loss is caused to the CD, okay, in IBC we always start talking about CD. If loss is caused to the company, then then that kind of suit can't be filed by the class. For filing a suit by a class, it need to be proved that this loss has been caused to the class only. If we try to understand this thing with an example, we can understand this thing that if debentures are being issued of two different categories, and in one category rate of interest is less, only in that case they can file suit under US laws for this particular purpose. But here, what interpretation? It's a preliminary interpretation. What interpretation the NCLT honorable bench has given in the Jindal's case is that they said even in the case of derivative action, it can be filed by the class also. This is I remember it's the principle which I've talked about in the US law country was that something tooth the principle is called tooth case or something tooth principle was there. So definitely, Mamta ji was a little bit skeptical that it may develop or may not develop as a professional practice. I feel that his her apprehension is also quite visible. Her apprehension is also right also. But with the passage of time, when we shall get maturity for all this thing there, if you look right now, same sort of protection is available under Consumer Act also. But in Consumer Act, a lot of cases are going on. People do file. Let's talk about in IBC terminology. Other we see quite parallel RERA. रेरा के अंदर बहुत सारी कंप्लेंट्स जाती हैं और लोग उससे उनका बेनिफिट भी उठाते हैं. तो ये एक मोमेंटम जब स्टार्ट होगा तो डेफिनेटली इट विल हेल्प आउट ऑल द माइनॉरिटी स्टेक होल्डर्स, whether they are the shareholders or depositor or otherwise. और एट द सेम टाइम जैसे जैसे ये डेवलप होगा, जैसे जैसे इसके अंदर लर्निंग आएगी, जैसे जैसे कोर्ट फेवरेबली करेगी, एसोसिएशंस या अदर थिंग्स विल कम आउट, एंड ओवरऑल गवर्नेंस जो है हमारी कैपिटल मार्केट की और अच्छी होगी, जो सेबी के आने के बाद बहुत अच्छी हुई थी. जैसे सर ने कहा कि सेबी के आने के बाद बहुत सारे डायरेक्टर्स को डीबार्ड कर दिया गया था, उनके डीमेट अकाउंट फ्रीज कर दिए गए थे. जब इस तरह के एक्शन या एक दो, जैसे इस केस के अंदर जिंदल की जो हम बात करते हैं, आई थिंक एलिगेशन इज ऑफ 2,500 करोड़ रुपए का एलिगेशन है. इस तरह के जब बड़े बड़े एलिगेशन आएंगे, उनके अगेंस्ट मे बी आफ्टर सम टाइम कुछ अच्छे रिवार्ड्स मिलेंगे या अच्छे कोर्ट ऑर्डर्स आएंगे, So it may be after some time, maybe 3-4 years gestation be there, but definitely it will improve overall governance of the corporate world and benefit to the minority shareholders, which is lacking at present if we compare our scene with other developed countries of USA, UK, or even Singapore, also Australia and New Zealand also.
Yes, Manoj, thank you very much. So, Mamtaji, I'm giving you the little bit of heads up. Now, we all are talking about the eligibility and the evidences which actually can be presented by even ex-employees. Even it can be presented by the auditors who are somehow is like kind of disgruntled auditor or disgruntled employees. So how this actually can be, don't you think it can be misused?
Yeah, Anilji, thank you for asking that question. हम मैं I just want the liberty to speak my heart out for this. कई बार हम देखते हैं कि कोई एक एक्शन सी जिंदल पॉलीफिल्म्स व्हाट हैज हैपेंड ऑन द फेस ऑफ इट स्टिल द मैटर इज सब जुडिस वी आर नो वन टू कमेंट ऑन दैट देर कहते हैं हिंदी में कि कहीं पे अगर धुआं है तो आग लगी हुई है, आग लगी ही है तो ही धुआं है. सो यू नो दीज आर सम एस्पेक्ट्स विच द कोर्ट विल डिसाइड. I have to make a point here which is more human in nature, that sometimes when we are in the act, we find it correct and we do it. एक दो साल when we look at the hindsight, हमें लगता है अच्छा ये इससे better हो सकता था, ये ऐसा हो सकता था, वैसा हो सकता था. But given the situation that you are in, everything will have a color gray, white, black. Beauty lies in the eyes of the beholder is the famous saying. तो हर ट्रांजैक्शन का कई बार ठीक है, मिनिमम इंफॉर्मेशन वगैरह तो सब लिस्टेड कंपनीज के लिए एलओडीआर में एप्लीकेबल है. एक कंपनी ये जो लॉ आया है 245, इट इज़ नॉट ओनली एप्लीकेबल टू लिस्टेड कंपनीज, इट इज़ ऑल्सो एप्लीकेबल फॉर अ प्राइवेट कंपनी और फॉर अ नॉर्मल क्लोजली हेल्ड लिमिटेड कंपनी विच इज पब्लिक इन नेचर. तो सभी में कई बार आपको लगेगा कि ये ट्रांजैक्शन उस समय तो ठीक था, but now later on the disgruntled word that you used, people may start using it as a weapon in their hands. आज सब कुछ ठीक है, everything is good, relationship is good, तो सब ठीक है. Later on they say. Now to actually bar this, अगर आप लॉ को देखेंगे सेक्शन 245, एक बहुत माइन्यूट वर्ड यूज किया गया है, हैव और इज बीइंग प्रेजुडिशियल. तो मतलब दैट इज वाई द कोर्ट हैज सेड कि ईदर दिस इज हैपनिंग और हैज जस्ट हैपेंड इन द रीसेंट पास्ट. आई रिपीट, सेक्शन 245 में कहा गया है दैट इट इज प्रेजुडिशियल विच मीन्स प्रेजेंट टेंस, और जजमेंट में जिंदल पॉली के जजमेंट और अर्लियर जजमेंट्स में कहा गया है इट मे हैव हैपेंड इन द रीसेंट पास्ट. 241 242 में हम लोग देखते हैं 8 साल पहले भी हुआ हो तो हम लोग आज आके बोल देते हैं वी हैव जस्ट सीन इट इन द एनुअल रिटर्न एंड वी आर अग्रीव्ड, सो माय लिमिटेशन स्टार्ट्स फ्रॉम द डेट ऑफ नॉलेज is what we write in 241 242. But in 245, to really address the point that you mentioned, Anilji, which was a very important and vital point, that tomorrow your relationship may get sour and you start invoking these provisions. So the court has actually said that it has to be for bona fide reasons, number one, and it has to be continuing or must have happened just in the recent past. Apart from that, I wish to inform my valuable people who are looking at the seminar that अगर हम इसको देखें तो it is also quite akin to a public interest litigation, which is happening under Order 1 Rule 8 of the Code of Civil Procedure 1908. That we are aware, Order 1 Rule 8 is being used in our country for days immortal. सो ऑफकोर्स उसमें भी हम देखा जाता है कि ये पब्लिक इंटरेस्ट लिटिगेशन का थ्रेशोल्ड को मीट कर रहा है कि नहीं, एंड वाकई ये पब्लिक इंटरेस्ट लिटिगेशन है कि नहीं. एंड वी सी डे इन एंड डे आउट that the High Courts and Supreme Courts exercise their jurisprudence and also threw away some of the petitions. And they also impose costs. Similar things will also happen here. Not all petitions will find their way through to cross the 245. It's not only the threshold, but the courts will also go and see whether this really has some genuine reasons, some genuine issues involved in the matter for which it should be invoked. Lastly, I want to say in this is कई बार हमने देखा कि आईबीसी में सेक्शन 10, हम सब जानते हैं कि सेक्शन 10 is filed by the corporate debtor itself. Now, section 10 is there in the law books, but we are aware that section 10 is hardly now used or hardly now actually even encouraged by the courts. तो कई चीज़ें लॉ बुक्स में रहती हैं, बट हम उसका कैसे, हाउ इज इट एक्चुअली spanning out in the courts is also a very important thing to be seen. I'm sure 245 will also have its own, journey. It is, let us also understand that this I say with some responsibility. जैसे अभी जब हमारे स्पीकर साहब ने कहा कि कंपनी सेक्रेटरी ने इमीडिएटली रिजाइन कर दिया तो जरूर कुछ होगा, ऐसा नहीं होता है कि जरूर कुछ होगा. एक प्रोफेशनल हमेशा, व्हाट आर वी आर प्रोफेशनल्स, वी हार्डली हैव द wherewithal to even fight a genuine case which is filed against us. Genuinely we know that ये गलत हो रहा है, but we are not able to fight it out because of the expenses. और हम अपना काम करें कि आजकल लिटिगेशन एक फुल फ्लेजेड काम बन चुका है. जो आदमी लिटिगेशन करता है वो प्रॉबेबली शायद और कुछ कर ही नहीं पाएगा, उसके लिए वही सब कुछ हो जाता है. तो एक प्रोफेशनल के पास, चाहे वो सीए हो, सीएस हो, ऑडिटर हो, कुछ हो, उसके पास इतनी वेरविथॉल नहीं होती है. वो हमेशा सोचता है इस कंपनी में कुछ झमेला आ गया, लेट मी कम आउट ऑफ इट. आपने देखा होगा कभी ईडी अटैचमेंट होता है, कुछ होता है, सबसे पहले इंडिपेंडेंट डायरेक्टर्स और केएमपीज रिजाइन करते हैं, नॉट बिकॉज उसमें कुछ उसकी कोई गलती है, उसमें कुछ होगा, बट वो लगता है झमेला से दूर जाओ भैया, हमें तो अपना घर संभालना है, घर परिवार चलाना है. सो आई एम ओनली सेइंग, जैसे आज कोई भी सोच रहा है यहाँ पे, उसी तरह ये लॉ भी सोचने लगेगा, हाँ इसी ने कुछ किया होगा. So I am only saying that this may become, if this is used left and right, and if it is not properly, monitored by the courts, I am telling you, there will be a flight of intellectual capital. You will not get people who would like to become KMPs. You will always find that these seats will be vacant and people will not like to take responsible positions. So I'm just saying, and if the lawmakers and the law takers are hearing this, my genuine request is that this should be sparingly used, where इसको यूज करने से ही फायदा होगा जन सत्ता को, तभी इसको यूज करना चाहिए. अदरवाइज दिस शुड नॉट बी यूज्ड. अगर 241 242 में थ्रेशोल्ड मीट नहीं हो रहा है तो हम 245 में आए हैं, then this should not be used. It should be highly discouraged.
So thank you, Mamtaji. I think you are absolutely right. I would only add into this particular subject that in case there are provisions in the section itself, protection of the companies or any kind of frivolous or vexatious applications. So section 245 subsection 8 says that the tribunal has the power to dismiss the application which is not even reaching the threshold. No, threshold is good faith, prima facie case, impracticability. That is all the tribunal will see. Also, the tribunal has the power to impose a cost of about up to 1 lakh of rupees. And for imposing cost, they actually have to record reasons. And even this, there is an exclusion for banking companies. And the banking companies are not, there cannot be any class action suit against banking companies as the, and simultaneously, I think we also would like to ask from Mr. Madan, because the section 37 of the Companies Act, I think that was existing in the law since 2013. So what exactly is section 37 and how do you compare this with the section 245? Madan sir.
Thank you, Anilji. Whether section 37 is there or not, that is immaterial, because under SEBI laws, SEBI has got inherent powers to take action against the promoters or the advisors or even the merchant bankers also if there is any wrong disclosure in the offer document or if there is any concealment in the offer document. So wherever there are wrong disclosures, there is concealment, maybe with respect to the price or valuation or other disclosure required to be given, There the authority has been given, power has been given to the regulator as well as the ministry to take action against the wrongdoers. So the power which is there in 37, that is with respect to the offer document, while here under 245, this action can be taken by the class of shareholders, class of deposit holders against the company and its directors and other senior management officials, including, as you discussed earlier, against the auditors and other consultants and advisors. Coming to the second issue, Mamta ji ne abhi kaha that I said in my remarks that कहीं कुछ होगा. Actually, ममता जी ने जो कहीं कुछ होगा मैंने जो बोला, ममता जी ने उसका रिप्लाई ही दिया है. कहीं कुछ होगा से मेरा मतलब ये नहीं था कहीं कुछ होगा ऑन द पार्ट ऑफ द कंपनी सेक्रेटरी. कहीं कुछ होगा ऑन द पार्ट ऑन दिस इन दिस एंटायर ट्रांजैक्शन कि जितने एक्शंस हो रहे थे उससे दुखी होकर कंपनी सेक्रेटरी ने कहा कि लेट मी गेट रिड ऑफ इट, लेट मी कम आउट ऑफ दिस एंड लेट मी बाय सम पीस. तो दैट वाज कहीं कुछ होगा व्हिच हैज बीन अप्लाइड इन दिस केस.
So I think you were right. In fact, the resignation. Sorry. Have you finished or no? I just intervened.
नहीं, अगर आप 2-3 मिनट और कुछ और देंगे.
Yes. Please go.
Touch upon some other issues if time permits.
Yes, please.
Time, I think still we have time. It's 1.5 hours was scheduled. We have to leave some time for the question answers.
Okay.
After Prashad sir's.
In the this 5th of February order, 5th February 2026 order, what NCLT has said and very beautifully with respect to US laws vis-a-vis Indian laws. I would like to read two operative paras from the order. The distinction between class and derivative actions under US law is not determinative in the Indian context. Indian law must be interpreted on its own terms. And the second is that foreign jurisprudence should not be imported where the Indian statutory framework is comprehensive and self-contained. What the court is trying to say is that our 245 is comprehensive. We have the provision with respect to the locus, with respect to the people against whom the action can be taken, and with respect to what actions can be taken. So our law is comprehensive. We need not look at any other law for this purpose. Then what the prayers which have been sought in this case, one prayer is the petitioner has sought the various reliefs, including declaring certain transactions as null and void, the transaction issuance of sale of shares and the granting of loan. Prayer with respect to compensation for alleged losses. And the third, disciplinary action against the independent valuers. So even the action has been sought against the valuers. Now our own professional brothers and sisters who are acting as valuers, giving their valuation reports on maybe on land and building of plant and machinery or other secured financial assets, I think they should be very, very careful and very, very vigilant. Manoj ji touched upon the concept, the term of debenture holders. Anil ji, in our earlier webinar also, I said that even debenture holders should have been included. But unfortunately, they are not included. Under 245, we are talking about only shareholders and deposit holders. Why debenture holders have been excluded, I'm not sure. That day we were discussing, yes, they are secured creditors. That might be one of the reasons that they have been excluded. But what sort of security is normally created, we all know that. Now, one major deterrence as per Rule 87 is that where this notice after admission, where this notice is to be published, that is actually very troublesome. This notice is to be published on the website of the company, is to be published in the newspapers, is to be published on NCLT website, is to be published on MCA website, is to be published on ROC website, is to be published on the website of the stock exchanges. And this notice will remain there till the time the main petition is discussed, it is decided, and it may take years together. This actually one issuance of notice and publication of notice will act as a deterrent for other companies. I tell you, Anilji, that this one single case may bring higher level of governance in the companies, particularly in the listed companies. That is what my observation is. I'm very positive about this issuance of notice. And I tell you, I don't know to what extent that is relevant in this case, recently on 13th of February, there was a board meeting of this company for the purposes of taking into consideration the financial results of the previous quarter. Can you believe it? The board meeting started at 7 p.m. on 13th and ended at 4 a.m. on 14th in the morning. It means in addition to this, so much would have been discussed, I'm presuming it. So much might have been discussed about the possible scenario or possible pitfalls of this particular judgment. So I think the deterrence has already started, and maybe the governance enhancement in the governance standard has also started. Thank you.
No, see, very right, Madanji. I think I would also like to highlight Section 245, subsection 2, which says that where the compensation is sought from an audit firm, the liability is extended to the firm and each partner involved in the misconduct.
Yes.
So this is also kind of a wake-up call for the auditors, wake-up call for the valuers, and also the company secretary. Now, the company secretary, in fact, probably resigned. I have no information about the facts of the company. We are only talking about something which is available on public domain. So
My information also from public domain only.
yes. So we see now, like since we have talked too much about the provisions, I think we have to get some, as Prasad Sahab started in the beginning. No, I would actually say that the Prasad Sahab, the honorable former member of NCLT, can give us the final, like they have to close this issue, and then we will have Manoj ji at least 10 minutes for question answer sessions.
या वी कैन हैव सर इसमें थोड़ा सा एक और बता दीजिए क्रिमिनल लाइबिलिटी का बिकॉज क्रिमिनल लाइबिलिटी इज अ वेरी बिग डिटरेंस फॉर ऑल दिस थिंग्स हियर is just like
No, criminal liability, I can actually tell the criminal liability because this very clearly it says that this is binding on the all this, as I said, the order is binding on the company, shareholders, depositors, directors, and section 245 subsection 7 deals with the criminal liability. Now, the criminal liability is whatever is the order from tribunal, it has to be complied with. So in case it is not complied, then the officer in default actually can be imprisoned up to 3 years, and there can be a fine also. So the fine and the imprisonment both are provided in section 245 subsection 7. That is only in case the order is not complied. As far as this, because this particular section is regarding compensation and it is regarding the restraint, it is not the criminal part of the activities. Now, in case the actions of the management is prejudicial to the interest of the company, they have to compensate. Prejudicial to the interest of the members, they have to compensate, and they have to pay for the damages. And even if it is prejudicial to the interest of depositors, so they have to compensate and they have to contribute for the damages. So I think Mr. Prasad can actually now say a final word on this. Yes, I think Madan Sahab also would like to say something.
On this criminal liability, Anil ji, आपने criminal liability के provisions बताए in section 245. But ultimately, if these allegations are proved, there may be possibility that NCLT may refer this matter to Ministry of Corporate Affairs to initiate an investigation under section 213. And after investigation, if the affairs of the company are found to be against the public interest, you never know, the matter may be referred to SFIO also, and then the implications may be too severe.
Yeah, that angle is open. That angle is also open. And here, compliance, we have to understand the common principle of criminal law, actus non facetrium nisi mansit tria. An act without criminal intention is not a crime, is not applicable here, because this is with reference to the compliance. Compliance, a dead date is given to do or abstain from doing a particular job, and if you don't do it within that time, you are liable. And as Madanji has rightly pointed out, there is a possibility of matter being escalated to SIF, fraud investigation officers also, when prima facie it proves fatal before the eyes of NCLT. But before referring it, the members will deliberate, think twice, thrice, then only they will do it. But still, there is a scope, as Madanji has remotely seen with his wisdom and eyes. I too agree that kind of possibility is also there. But whatever it may be, this judgment has created a kind of new opening for professionals, and now all the professionals are more responsible for their deeds and misdeeds, and they should have absolute due diligence before they walk. Before every step, they have to look back and see how far it is protecting the interest of the company. Only when they come to a conclusion it is protecting the interest of the company, they should go a step further. Otherwise, refrain themselves from suggesting to act upon.
So thank you very much, Mr. Prasad. From the panels, in case anyone would like to say anything, otherwise, then we will open it for question answers from everyone. And Manojji, I think we can actually ask the organizers, the person who is sitting on the technology, he can actually allow everyone to unmute and ask their questions. We would only say that anyone who is asking a question should also switch on the videos, please.
Yes, yes.
Mamta
Yes,
ji,
in
can
case
you
Mamta ji, you
start
would like
with
to add
Yes,
something?
yes, sure.
Mamta ji, can you start with the chat box questions
Yes,
firstly?
yes, I will.
Yes, please.
So there's one first question which had come from Advocate Raghu, that can personal reasons for resignation be given from board of listed companies? Evidence, requirements in 241 proceedings, settled position. Anyway, whether NAFRA could be impleaded to give teeth in case of listed companies. So the first question, of course, I'm just taking the liberty to answer because I do this every day. Personal reasons for resignation from board of listed companies cannot be given. That's very, very clear as per the provision given in the LODR. In fact, LODR, Advocate Raghu, sir, you've also raised your hands. In fact, LODR also goes on to say, when you write the reason, you also have to write below to confirm that apart from this, there is no other reason to resign. And personal reason is not a descriptive reason. Or else sometimes people write due to preoccupation. That is also not a reason, because if you have preoccupation, the SEBI goes on to check whether what are the number of other boards that you are occupying, say for example as an independent director, etc. So can you say that only from this board, if you get free, your preoccupation will go less than what you expect? So therefore, personal reasons is definitely not a valid reason. Yes, Raghu sir, since you have raised your hand, you can put on your camera if you wish to say anything more. And NAFRA could be pleaded or not to give teeth. I'm sure Anilji would like to say something on this, but definitely, I mean, everybody and anybody in the whole world can be asked to be impleaded. There is nothing that stops the arguing counsel or anyone else to say that this
Yeah.
person could be not impleaded.
Yeah.
Anyone could be impleaded, but it depends on whether the need of it and whether you should do that.
No, I
Yes,
think
sir.
as far as this
Nice
NAFRA
to
is
connect with
concerned,
you, madam. Nice to connect with you after long years, because I used to be with the IBBA on some of the committees in
Right,
that.
sir.
Now, coming to the specific point, the reason I asked why boards, we saw in the course of our discussion today that the company secretary leaves with personal reasons. Why can't we apply the same standards as we apply for the directors to KMPs also, that they cannot write like personal reason and get away from the situation when
Raghu
it
sir,
is
it
becoming
is
hard?
applied. He has just done it, and I'm sure he'll be questioned.
100% I feel SEBI should go behind this, because these are all listed companies. Now coming to, I will just take another 1 or 2 minutes if the panel permits me, a couple
Yes,
of
yes,
points.
please carry on, but
Yeah.
be brief. To the point.
I will take about 90 seconds, please. Issue is, we need to bring in deterrence in all these enforcement. For example, as madam was saying, 10 years has taken for even to get the first stage of admission. I am 100% sure my colleagues will be seeing it with a lot of judicial review. I will not be surprised even if they go under 226 to squash the authority of NCLT itself, and when there is no prima facie evidence that is addressed. The larger point I'm raising it before all of us is to share these 245 provisions which was introduced, even the shareholders activism. We have seen many institutional investors have brought in actions against corporate decisions like executive compensation, etc. in the past, especially mutual fund and others. So I feel we must recommend that this 2% threshold should give given exemption to institutional shareholders activism. That's all my submissions. So that the class will have really effective, because institutional investors will have the resources. Unlike others, the individual investors, the institutional investors will have much more teeth, and we can make it mandatory through appropriate disclosure of such activism so that the corporate governance in the country improves better. That's my submission to all of you.
So, in fact,
Thank you.
Mr. Raghu, I would say this particular section, the activation, like the notification in 2016 and thereafter the formation of rules, it is primary to attract more investment in India from other countries. So presently, India was not having this class action suits because see the investors who come in India and they trust on the existing management, they invest in their companies, and later on they find that in case the management is not working in favor of the company or the shareholders, then they presently find no kind of remedy. Like, as I said, this particular case, Jindal Polyfilms, has actually taken 2 years' time. It is not 10 years. From the date of filing of this application, it has been admitted in 2 years. And that also because it was the first case and there was no precedence of admittance before this. In future, in case the capacity of the tribunal increases, I believe it would be admitted quickly, provided the evidences are strong, or it will be rejected. Now, let us understand that the protection is required to international investors, also domestic investors, and that is what is the growth of the Indian economy and the corporate sector. Like saying that it should not be available to institutions, I believe the objective is only to give some kind of protection to those shareholders who are not part of the management.
Adding to Anil's point, it also strengthens the existing corporate governance structure.
Yes.
And it boosts up the image of the organizations because of the 245 indirectly threatens the actions. So it is for better corporate governance also, apart from boosting the investments. And it was there, such kind of provisions are there in other countries' Companies Act also. So investor will see what is there in their country and how their country companies are successful and what is not there in India. That is how the provisions of IBC, the law of IBC has come into existence. That is how the new Companies Act has shaped. These are all on a analysis of what you have and what you don't have, and how do you strengthen what you don't have. In fact, 245 provision introducing and the rules and this judgment is a kind of a roadway, and how far it makes it a good flyover, we have to wait and see. Now it has created a roadway. This roadway has to be turned into a flyover so that nothing comes in between, the actions go smooth. So we have to wait and see. But the rationale of the whole judgment is clearly very good. And I request every participant of this seminar to read it twice, thrice, analyze yourself, raise as many questions as possible to all of us by your emails, so that we will also start thinking from that angle.
So yes, I see. I would also like to add what Mr. Prasad has said. Like, as far as the IBC is concerned, that is applicable only if there is a default. Now think of a situation that there is no default in the company and still some people are aggrieved from the conduct of the management.
Correct.
Where do they go? They see, like when we go to Companies Act under Section 241, 242, then we find that the kind of reliefs which are available in that Section 241, 242 are probably like regulate future affairs, maybe regarding some purchase the shares of oppressed members, and then removal of some of the directors, or like kind of
Correct.
like kind of
Correct. The
invalidate the
remedies,
removal of some directors.
choice of remedies are limited. Now, choice of remedies are greater.
No, in Section 241 and 242, there is no remedy of damages. There is no remedy of compensation.
Now, that is what I'm saying. Now,
So,
the remedies are greater.
much
Earlier, the remedies are restricted.
Yeah, it was only restrictive, and now the remedies are much larger, and the eligibility is much lower. In Section 240 to 242. Yes, Mamta ji.
No.
Yes,
So,
you wanted to say something.
yeah, so I was just asking that let us just inquire whether anybody else also has any other question.
Yes,
Yes.
please. Yes.
I have taken care of the questions that I had in the chat box.
And
Anybody
I
else
just put
has-
the email address also, as Mr. Prasad sir said. अगर किसी की कोई भी बात है, चाहे वो related to this case or related to IPA, they can mail us therein. Mamta ji, please carry forward.
Yeah. You may please take note of the email ID. Please feel free to ask or share your views, etc. Anything on the subject. So we should close because we believe in starting on time and also closing close to the time जो हमारा निर्धारित किया रहता है. Thank you very much for joining in. These sessions sometimes, there's a famous saying by a lot of people who hold a lot of ground as a professional, that sometimes sessions need not be there to kind of overburden you with the law, the scheme of things, the rules, the regulations. These kind of sessions are more so done so that you start thinking about it. You get sensitized about the subject, you get sensitized that something has happened, and then you get interested to read more and know more. So IPA and all the team of IPA, of course, will keep on doing such sessions. Please do join us and enlighten not only yourselves, but also the community that you are serving. Today, knowledge is probably the highest power. जो हम अपने देश का भी देख रहे हैं, our goodwill has become the most softest and the best power that we possess. Hardest and the softest.
Adding to Mamta's point, knowledge, in fact, not only power, it is the weapon.
Absolutely, sir.
That is why only we bought Right to Information Act. We
Right,
have
sir.
given weapon to the citizens. Like that, this information, what we are sharing to these seminars is nothing but we are trying to give some weapons to you all so that you can sharpen and use them appropriately whenever it is required.
Absolutely. And today, when the whole world is looking at India for not only nuclear power, etc., but the AI power, the power which is going to either take the world head on or sometimes even have the destructive powers, when India is even rising above everybody else to prove that even in AI, it is going to be the superpower, let us all come together and bestow our best wishes to the ruling dispensation of our country and to all of us, that we also rise in this power and make a name for ourselves. With these, thank you very much for joining in, and we look forward to have you in our next other session.
Thank you to our course participants also, like IBC Law, GIPA, Kerala Insolvency Professional Firms, and NCLT Kolkata Bar Association, and to our esteemed guest, Mr. Prasad, Mr. Madan, Mr. Anil also. I must confess you one thing. They people are very, very busy. In fact, Mamta is and me also very busy. But we have one, something in our heart. Something in heart. Society ने हमारे को इतना कुछ दिया तो हम भी society का कुछ दें. That is the only objective for which we are running this IPA and holding these webinars and all this thing there. Thank you very much. Thanks a lot. Keep encouraging us by more participation. Thanks a lot. Thank you.
And to become a member of IPA, we'll be very happy to have you as our member.
Yes.
Nothing, it's no cost really, just a very small token. We can share, we've already shared. Please become a member of IPA and give us the opportunity to meet more. Thank you so much. Thank you.
Thank you.
Thank you. Thank you, Anil sir. Thank you, Madan sir. Thank you very much.
Thank you very much.
Thank you,
Thank you
everyone.
all the audience. Thank you for participating. Thank you.